Please be seated.
Good morning to all. The court's in session now. May we have the appearances for the parties, starting with the prosecution.
Good morning, Madam President, Your Honors. The prosecutor is represented by Tembele Seguete, Appeals Counsel, Sharif Adong, Case Manager, and myself, Chief of Prosecutions.
Thank you. The defense.
Bonjour, Madame le Président.
Good morning, Madam President, Your Honors. Dear colleagues, the defense team is made up today of Mr. Marufa Diabira, lead counsel, Chloe Garden, legal assistant, and myself, Dorothée Lefrappé, du Hélène co-counsel.
Thank you. Here's the summary of the judgment in the case of prosecutor versus Dominique Ntawukulilyayo. The accused in this case is Dominique Ntawukulilyayo, born in 1942 in Mubuga Commune, Kigongoro Prefecture, Rwanda. In 1994, he was the sub-prefect of Kisigara Sub-Prefecture in Butare Prefecture. The prosecution has charged him with genocide and complicity in genocide, as well as direct and public incitement to commit genocide. The defense disputes all the charges. The trial commenced on May 6, 2009 and closed on December 17, 2009. The prosecution presented 12 witnesses, while the defense called 23, including Ntawukulilyayo. Closing arguments were heard on June 14th of this year. The chamber is not unanimous with respect to count 1, that is genocide, of the indictment, but is unanimous with respect to counts 2, complicity in genocide, and 3, direct and public incitement to commit genocide. The judgment is rendered pursuant to Rule 88C of the Rules of Procedure and Evidence. It will be available soon. The following is a summary of the central findings concerning the allegations against Ntawukulilyayo. A number of decisions about allegations not pursued by the prosecution and issues pertaining to the fairness of the proceedings are discussed in the judgment and will not be read here. Only written judgment is authoritative. First, events at Gisagara Market and Kabwe Hill. The indictment contains a series of allegations concerning events at Gisagara Market and Kabwe Hill between 20th and 25th April 1994. The evidence clearly establishes that on 20th April, hundreds to thousands of Tutsis and their families fled attacks in their localities and sought refuge at Gasagara Market in Andorra Commune. Some of these displaced persons tried to leave the market that evening and following morning, but was stopped by law enforcement personnel and forced to return to Gasagara Market. The evidence further establishes that on the morning of 21st April, President Theodore Sindiko Babu arrived in Gisagara and held a brief public meeting near the sub-prefecture office, which was attended by Ntawukulilyayo and others. In his brief address, Sindiko Babu referred to the 1959 revolution, during which ethnic violence erupted between Tutsis and Hutus. From that day and through 23rd April, many of the refugees left Gasagara Market for Kabuye Hill. There, an extensive assault on the refugees were carried out by armed civilians, police, and military personnel. Hundreds and possibly thousands of men, women, children, and the elderly were killed or seriously injured. The Chamber considers separately the allegations against Ntawukulilyayo with respect to events at Gisagara Market and Kabuye Hill. Interception of refugees fleeing to Burundi. The indictment alleges that between 20th and 21st April 1994, Tutsi refugees who attempted to leave Gasagara Market for Burundi were prevented from doing so by soldiers and communal police on the orders of Ntawukulilyayo. The Chamber heard consistent evidence that the refugees left Gasagara Market early in the morning on 21st April, but were stopped some distance away by law enforcement personnel. They returned to Gasagara Market. The evidence, however, does not establish beyond reasonable doubt that Ntawukulilyayo had any role in the interception and the forcible return of refugees to Gasagara Market. Furthermore, it is not established that when the interception occurred, a plan was in place to gather Tutsis at the market for express purpose of killing them. Accordingly, this allegation is not proved beyond reasonable doubt. Orders to go to Kabuye Hill. The indictment alleges that around 23rd April 1994, in the afternoon, Ntawukulilyayo ordered Tutsis at Gasagara Market to move to Kabuye Hill to be protected and fed. However, when they arrived, they were attacked by various assailants and killed. The prosecution presented evidence of Ntawukulilyayo's involvement in instructing refugees at Gasagara Market to go to Kabuye Hill on 21st, 22nd, and 23rd April. The Chamber has considered the evidence of alleged orders on each day. With respect to 21st April, 3 prosecution witnesses testified that Ntawukulilyayo gave orders to refugees to move to Kabuye Hill. However, 2 distinct narratives emerge from their evidence. The Chamber considers that their testimonies, when viewed in isolation and as a whole, are insufficiently reliable to support findings beyond reasonable doubt. Turning to orders on 22nd April, one prosecution witness who was among the refugees at Gasagara Market testified that she saw communal police leaving Ntawukulilyayo's home. They subsequently ordered her and other refugees to move to Kabuye Hill. She concluded that the police gave these orders pursuant to instructions from Ntawukulilyayo. The Chamber has doubts about her observations. They also lack specific corroboration. This evidence cannot support findings beyond reasonable doubt. With respect to orders on 23rd April, the Chamber, Judge Akai, dissenting, finds that 2 prosecution witnesses provided compelling and largely corroborated evidence on the early afternoon of that day. Ntawukulilyayo and Calix Kalimanzira came to Gasagara Market together. Communal police gathered remaining refugees, mostly Tutsis, for the purpose of directing them to Kabuye Hill. The refugees who were promised by Ntawukulilyayo that they would be fed and protected on the hill complied with his instructions and were escorted towards Kabuye Hill by communal police. The testimony of the defense witnesses were of limited probative weight and insufficient to raise doubts with respect to the prosecution evidence. Orders to search Tutsi homes. The indictment alleges that between 21st and 25th April 1994, Ntawukulilyayo ordered civilians to search Tutsis' homes for the purposes of assembling them at Kabuye Hill, where they were ultimately killed. The prosecution relied on 2 witnesses, their accounts referred to separate events and did not offer direct corroboration. The Chamber has reservations about the reliability of both witnesses. Consequently, this allegation has not been proven beyond reasonable doubt. Attack on Kabuye Hill. The indictment alleges that between 21st and 25th April 1994, Ntawukulilyayo transported ammunition, soldiers, and gendarmes from Buchari to Kabuye Hill. It further alleges that around 23rd April, in the late afternoon or early evening, Ntawukulilyayo arrived at Kabuye Hill with Calix Kalimanzira in vehicles full of gendarmes. There, soldiers, gendarmes, communal police, and armed civilians participated in the killings of as many as 25,000 Tutsi refugees on Kabuye Hill. One prosecution witness testified that Ntawukulilyayo arrived at Kabuye Hill on Friday, 22nd April, with soldiers. The Chamber has considered this evidence insufficiently reliable. Three prosecution witnesses who had sought refuge at Kabuye Hill testified that on 23rd April, Ntawukulilyayo arrived with armed security personnel, including soldiers. Two observed Ntawukulilyayo with Calix Kalimanzira. Ntawukulilyayo's presence was brief. The security personnel who had accompanied him to Kabuye Hill joined other assailants and attacked the refugees there. The Chamber, Judge Akai, dissenting, has found this evidence consistent and compelling. Having reviewed all relevant defense evidence, the majority finds that it carries limited probative weight and does not raise doubt. Accordingly, the Chamber, Judge Akai dissenting, finds as follows. Ntawukulilyayo arrived at Kabuye Hill with Calix Kalimanzira and soldiers in the late afternoon or early evening of 23rd April 1994. Ntawukulilyayo stopped at the hill, allowing the soldiers to exit. Shortly thereafter, he and Kalimanzira departed, but the soldiers who had accompanied them joined others, including communal police, in an extensive assault on the civilian refugees using firearms and other weapons. The record does not establish that Ntawukulilyayo returned to the hill. However, the coordinated attacks continued into the following day. As a result of the attacks, hundreds and possibly thousands of civilians, mainly Tutsis, were killed and injured. Second, roadblocks. The indictment alleges that within few days of President Habyarimana's death on April 6, 1994, several roadblocks were established in the Gesagara sub-prefecture and run by armed civilians and other subordinates of Ntawukulilyayo. One was the Jaguar roadblock near Gesagara Catholic Church. Another near Ntawukulilyayo's residence. And third, the trading center on the road towards Mosha. During the period 6th April and 17th July 1994, the roadblocks were used to prevent Tutsis escaping from the area or to kill them. Many Tutsis were killed at these roadblocks. According to the prosecution, Ntawukulilyayo was aware of and acquiesced to the establishment of the roadblocks and in some instances passed through them, congratulating and encouraging killers to continue their work. The prosecution has conceded that no specific evidence was led in support of 3 roadblocks identified in the indictment. It relies primarily on the testimony of one witness. It has also conceded that his evidence is not clearly pleaded in the indictment. The Chamber has found the defense has not received clear and consistent notice of this evidence, as it is highly prejudicial. The Chamber has excluded it. Excuse me. The Chamber has considered all the other evidence relevant to the roadblocks and found it insufficient to support findings beyond reasonable doubt. Third, meetings. Meeting in near Rohingya commune around 24th April 1994. The indictment alleges that around 24th April 1994, Ntawukulilyayo addressed a public meeting in Gigoro, Mutabori, near Rohingya commune. He promised houses, land, and money to those who killed the most Tutsis, thereby inciting them to do so. The prosecution presented one witness who testified about a gathering in Kigoro, on 15th May 1994. The prosecution conceded that his testimony was inconsistent with amendments made to the indictment for the purpose of clarifying the date. The Chamber has considered the evidence but found that it cannot support findings beyond reasonable doubt. Meeting in Muyaga Commune, end of May 1994. The indictment alleges that near the end of May 1994, Ntawukulilyayo urged those gathered in Muyaga Commune in front of the house of the Deputy Bookmaster to search for and kill Tutsis before the arrival of RPF. The prosecution relied on the evidence of two witnesses. The Chamber has considered that they discussed different events. Having reviewed the individual merits of their accounts, the Chamber finds the evidence insufficient to support findings beyond reasonable doubt. Accordingly, this allegation has not been proven. Meeting in Kirarambogo, near Batari sector on 25th May 1994. The indictment alleges that around 25th May 1994, Ntawukulilyayo attended a meeting in Kirarambogo in near Batari sector, where other officials instructed those present to flush out and kill all surviving Tutsis. The prosecution relied on the testimony of one witness. The Chamber has considered uncorroborated evidence insufficiently reliable to support findings beyond reasonable doubt. Accordingly, this allegation is not proven. Findings. The trial chamber finds in respect of Dominique and Ntawukulilyayo as follows. Count 1, genocide. By a majority, Judge Akai dissenting, guilty. Count 2, complicity in genocide, not guilty. Count 3, direct and public incitement to commit genocide, not guilty. Before I announce the sentence, I would ask Dominique and Ntawukulilyayo to please stand up. Now the sentencing. The Chamber, Judge Akai dissenting, has considered the gravity of the crime for which Ntawukulilyayo has been convicted, as well as aggravating and mitigating circumstances. Considering the relevant circumstances discussed in the judgment, it sentences Dominique Ntawukulilyayo to a single sentence of 25 years of imprisonment. In accordance with Rules 102A and 103, Ntawukulilyayo shall remain in the custody of the tribunal pending transfer to the state where he will serve his sentence. This marks the end of the ceremony of the judgment. The trial proceeding in this case have come to an end. Thank you.
All rise.